In this video, I'm going to be explaining what you should do if the petitioner at a domestic violence restraining order hearing brings up new stuff that they never wrote in their application for the temporary restraining order. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course called Defeat the DVRO, in which I teach you how to represent yourself at your restraining order hearing and win. And again, in this video, we are going to be talking about this situation where you get a temporary restraining order, you get a bunch of allegations, many of which may not be true, in this application for the restraining order that were written by the petitioner, by the person asking for the restraining order. But then you show up at the hearing and they say a bunch of stuff that they never wrote in their restraining order. How do you bring that up to the judge? What do you do with that? Are they allowed to do that? Is that significant? This is obviously a really frustrating problem to encounter, but there is a way to use it to your advantage, and I'm going to teach it to you right now. So let's jump right in. Okay, so the technique that I am going to teach you, and trust me, it is easy. It's easy, and you'll have a template. The technique I'm going to teach you is a form of cross-examination. Cross-examination is just asking the other side questions, asking the petitioner questions if you're the respondent. And how this works is that at the restraining order hearing, the petitioner is going to get a chance first to tell their side of the story. The judge may ask the petitioner, okay, I read your papers. Is there anything else that you want to say? And now they have said a whole bunch of stuff that is not in their paperwork, that is maybe much more severe than what they put in their paperwork. Well, after they're done speaking, you will get a chance to ask the other side questions. Now, I have seen so many people screw this up. If you've been to court for a restraining order before, maybe it got continued one time and now you're trying to prepare yourself, you know what I mean when I say that you sit there all day. So you see many of these restraining order hearings and you see people screwing them up. Many people will not ask the other side questions because they have no idea how to ask questions. Other people will ask questions in an aggressive manner, in an ineffective manner that is so bad that they're just leaving a terrible impression on the judge, and it would be better if they didn't ask questions at all. But you'll see that attorneys do ask questions, and it's not rocket science. There are formats, there are templates for how to do this. There are only so many different types of questions that you can ask, and so many different ways to do it. But this one is really important. Okay, so you are in the situation where the petitioner has now finished their testimony, and now it's your turn to ask questions. How do you ask? How do you bring this up? Okay, so here is how you're going to do it. I'm going to give you a template for this, but let's go through an example first, okay? So the new allegation that was not in their paperwork was that at one point during the relationship, you pointed a gun to petitioner's head. Serious stuff, right? But it wasn't in her paperwork. So what you would say in that situation, you would start out with, you testified a few minutes ago that I pointed a gun at your head. What you're doing there is you are redirecting the judge and redirecting the petitioner to what you're talking about so that the judge understands where you're going with this and everybody is kind of on the same page. The second thing that you ask is, and pointing a gun at your head was a pretty serious instance of abuse, correct? What you're pointing out here, and this is obviously an extreme example, but you're getting the petitioner to admit that this was something that is significant. And the petitioner is readily going to say yes to this, right? They want it to seem like a serious instance of abuse. They're probably going to be very happy that you asked that because they don't know what's coming next. The next thing that you say is you submitted to the court a declaration describing all of the abuse that you claim that I committed. And what I'm talking about there is the application for the temporary restraining order that the petitioner submitted to the court. In that packet, they are saying all the reasons why they need a restraining order against you, all the most important allegations, the most serious things, the reason why you should be deprived of your rights and not even given notice about it first is because of all these serious instances of abuse. So you would expect them to put all the most serious things in there. Not write about the one time when you yelled at them, another time when you grabbed their arm too tightly, but not bring up this whole gun to the head thing, right? And then step 4, the fourth question is going to be, isn't it true that nowhere in your declaration do you just describe me pointing a gun at your head? You would have put it in there if it was important. What you're implying to the judge is that this didn't happen, and between the time that the petitioner filed the TRO, the temporary restraining order request, and the time of the hearing, the petitioner has made this up. Okay, and here is the template for it. Step 1, you testified a few minutes ago that, and then you're going to put the summary of the brand new allegation. So in the example that we went through, the brand new allegation was that I pointed a gun at your head. Step 2, and then again, it's going to be the same summary of the brand new allegation that you used in step 1. And summary of brand new allegation was a pretty serious instance of abuse. Step 3, you submitted to the court a declaration describing all of the abuse that you claim that I committed. And then step 4, isn't it true that nowhere in your declaration do you describe summary of brand new allegation? So literally the only thing that you are filling in the blank for is the summary of the brand new allegation. So obviously when you're going into this restraining order hearing, you don't know what brand new stuff they're going to say on the spot, right? Especially if it didn't happen, they're just making it up. You have no way to know what they're going to just stand there and make up. But all you have to do for this is have your template and then have this summary of the brand new allegation. Okay, so in another example, let's say that she gets up there on the stand and says that you threw a bottle of whiskey at her head on Thanksgiving Day. It narrowly missed her head and it hit the wall, fell to the ground, and shattered. The summary of that would be threw a bottle of whiskey at your head. So you would say step 1 would be you testified a few minutes ago that I threw a bottle of whiskey at your head. I threw a bottle of whiskey at your head. That is the summary of the brand new allegation that you would use for each one. So there's not a whole lot that you're going to have to think about during your hearing. You can summarize it, and it doesn't have to be absolutely perfect. If it's you punched her in the face one time or slapped him in the mouth and made his mouth bleed. But let's say you said punched you in the face and gave you a black eye, or you said punched you in the mouth and made your lip bleed. That would be fine too. Just summarize it as best you can, fill in the template, you're doing it on the fly. Even if you don't get it absolutely perfect, you are still going to be in probably the upper 1% of respondents in how you are able to bring this to the judge's attention. And look, you have to remember one of the reasons for doing this is that the judge has so many of these cases every day. And imagine focusing on something for 8 hours, different people's stories coming in and out. Your mind starts to wander. You have these documents in front of you, but you probably don't have very much time to review them. These courts are slammed. So you want to make sure that you point this out to the judge. Make it easy for the judge. Present your evidence in a way that makes it super easy for the judge to see that, wait a second, that is a serious allegation. You mean to tell me that she didn't include that in there? Why would she bring it up today? These hearings are all about credibility, and anything that you can do to throw rocks at the other side's credibility, because the judge only needs to find in one side's favor slightly more than 50%, ever so slightly more than 50% in order to rule in their favor. And the judge has like a minute to decide. In fact, even less than that. Generally, the judge will give you a decision immediately as soon as everybody's done presenting evidence. So the judge probably decided pretty early on which side to pick. You want to make sure that you take these opportunities, that you discredit the other party whenever it's important. Now, only use this when it's an important detail, when it's a new allegation of abuse or something that makes one of the other allegations that's in the petitioner's paperwork much worse. For example, maybe they describe some active abuse in the paperwork, but now they're saying they had some really horrible injury from it that they did not describe in their paperwork. That's when you would want to bring it up. If it's something very minor, the judge is going to grow impatient, you're going to look petty, and it could negatively impact your credibility. So just be careful with this. Use your best judgment. And you can do it. I mean, the thing about these hearings is they are set up for people to represent themselves, but most people have no idea really what to do to win these hearings. But usually people don't really know what to do to win these hearings or to swing the pendulum in their favor. And what they end up with is a judge just looking at two people, having no idea who's more credible, neither party knows what they're doing, and just kind of flipping a coin. So if you can weigh the scales even a little bit more in your favor with techniques like this, with objections, and I think they're going to end up being a lot more in your favor, then you have a very good chance at winning the hearing. In the course, I'm giving you everything that I do to go into one of these restraining order hearings and win easily. And it's not rocket science. I mean, the thing is, law school, they teach you so much stuff, right? They teach you so much in law school. And when you first start being a litigator, you are learning many different techniques. But the thing is that for these restraining order hearings, what I noticed after a while is there's only a very small little portion of all of that knowledge that I had to learn for the bar exam, for law school, for murder trials. There's only a very small amount of that is actually needed for these restraining order hearings. And so if I just give those to you, that little slice, in a way where you can easily digest it, you have a template, you just fill in the blank. You can do it, you can win, and really the course is your secret weapon to winning your hearing. And you can actually get your free first class in the course down below. It will kind of give you an overview of what you need to learn for the hearing, what to expect from the course. It will explain what the judge is looking for, and even if you only end up taking the class, you'll have some pointers that will definitely help you with the hearing. And I hope that you found this video helpful. If you did, please don't forget to like, subscribe, and ring the bell.